Bryan Kohberger sees two major court orders. A blizzard of motions are filed, and there's reference to a naked motion. But we're going to plow right through in the Kohberger case.
In a flurry of paperwork, some of those documents give the details on what happened the day that Bryan Kohberger was arrested. I'm Lainey Law.
And I'm attorney Andrew Myers.
And Andrew, you are going to have to walk us through what's going on with all these different documents that we're going to be talking about today. It seems like everything's just kind of exploded at this point.
Well, the issue is that Ann Taylor wanted to bring this case to a new court, and she did that. And I'm just wondering if, based on what we're going to see right now, she's happy with the fact that she has really been handed her head in a basket. The first court order we're going to take a look at is an order denying her request for discovery. Ann Taylor had asked for what's called leave. That's just a fancy legal term for permission. She wanted permission to go ahead and file more discovery. I think she's filed 18 discovery motions and half a dozen motions to compel. And the court kind of let her know that she's reached the limit. So this is what the court said to her: an order denying a motion for leave. Before the court is defendant's naked motion for leave, in which he seeks relief from the discovery motions deadline of November 14th. As you know, that's passed, as set forth in the governing schedule order. Defendant asserts his counsel and investigators are still reviewing the vast amount of discovery in this case, and therefore he needs additional time to file motions related to discovery. Motions to enlarge a deadline filed on the eve of the deadline are not well taken. So that's the first kind of, sharply worded comment that Judge Hippler has handed to Ann Taylor and her group. The state's discovery deadline was September 6, 2024. Defendant could have ascertained far sooner whether the discovery motions for deadline would pose a difficulty and brought it to the court's attention. Further, and importantly, the defendant has not demonstrated with his filing good cause to enlarge the deadline. He has not set forth what efforts have been made to review the discovery, what portion of discovery has not yet been reviewed, why it has not been reviewed, or how long it will take to complete such review. Consequently, his motion is, in big letters, denied.
Now, it sounds like on their part, they had seemingly a lot of different oopsies because they have a lot of different points that they make as to why it's denied. But what is this naked motion that they're talking about?
Well, I thought about how to explain that, and then I saw our friend Yoli Medina, the civil attorney from California.
Our fave.
She had a really good explanation. So Yoli is going to explain what the judge meant when he called it a naked order or a naked motion.
When he says naked motion for leave, I believe that what he's referring to, it's naked because it doesn't have any explanation. It doesn't have good cause. I know that in civil cases, we do have to provide a declaration stating our efforts of what we tried to do, what we've looked through so far, what is at issue, and why you can't review it in the time allowed by the court to bring your motions. And that was not detailed. And so I do think this is a proper order. I mean, you have to tell the judge why you haven't reviewed it and how long is it going to take you to review it.
I thought that was a good explanation. I really did. And I thank Yoli. We spoke to her after she posted her explanation, and she said, go right ahead and use that, which we have. And she does good work if you want to check out her channel. But what she's saying, I think, was clear enough. But when we file motions in court to enlarge or extend a deadline, the court wants to know why. And that's what good cause is. And generally speaking, in fact, I filed one in one of my civil cases recently. You've got to have a really good reason. The top reasons are an illness or death. And thank God, we're not talking about that. In a case I was dealing with, new parties came in. And there were new attorneys. And that's kind of the same in the Kohberger case, that she could have said, well, the old prosecutors are kind of waning and we have new prosecutors and a new view. And I mean, maybe that would be, you have to articulate something. I found generally speaking, with a few exceptions, the courts want to work with attorneys. The judges on the bench were attorneys, and they know that sometimes we do have reason to have more time. So if you just give them something to hang their hat on, it's called good cause, it would have been more likely. The other thing is we do have a lot of discovery from Ann Taylor. So I don't know. Does that make any sense?
No, it does. And it kind of, I don't know. Obviously, we don't know the exact details of what's going on, but it does almost reflect badly on the defense's part, because why are they doing this so late and why aren't they detailing the exact reasons? I mean, even the fact that they have so much information in the first place could be part of a reason, but it sounds like they just were a little bit of negligent in providing everything that they needed to provide.
Just give the judge something.
Yeah.
Give him something, anything.
Anything.
To why.
Let him help you. Help him help you.
Yeah, I think he's seen enough of the discovery that's come out of Moscow. He doesn't want any more of that in Boise.
Mm-hmm.
So now the next order that just didn't really go her way. Remember all those motions on the death penalty? Mm-hmm. There were 13, 14 motions, and then even more motions in opposition from the prosecution. Where's the buzzer? Because they were all ceremoniously denied with one sweep of the pen by the judge. This is the memorandum of decision and order on the death penalty motions. And rather than read the whole thing, which I think is really boring, we're going to tell you what's really important. This is the Cliff Notes version, but all the important stuff and the reasons why the judge has said, no, you're not going to strike the death penalty at this time. The defendant moves to strike the state's notice on grounds that Idaho's capital sentencing scheme fails to narrow the class of first-degree murderers who are death-eligible defendants, thus permitting an arbitrary and capricious selection of defendants for death. Well, in opposing capital punishment, Idaho has a constitutional responsibility under the 8th and 14th Amendments to the U.S. Constitution to tailor and apply its laws in a manner that avoids the arbitrary and capricious infliction of the death penalty. And there's the case, United States Supreme Court case. To accomplish this, Idaho's capital sentencing scheme must provide a meaningful basis for distinguishing the few cases in which the penalty is imposed from the many cases in which it is not. So the court bases all of this and all of its arguments on a lot of law that we're skipping past. If you're an attorney, go read it. It'll make a lot of sense. Defendant contends Idaho's scheme has so many aggravating circumstances, so broadly construed, that the aggravators accomplish no narrowing and create a greater risk of arbitrary death sentences. However, the Idaho Supreme Court has determined that Idaho's approach accomplishes the narrowing function in the eligibility phase as required by the U.S. Constitution. So, not so much for the motions to strike capital punishment by the defense team. As if that's not enough, moreover, the judge writes, in challenging Idaho's scheme, defendant improperly focuses on the statutory aggravating factors in the aggregate rather than individually. This approach was rejected by the Idaho Supreme Court in a case that's known as State versus Hairston. And the court goes on at length to brief that case and then points out that Kohberger, defendant's attempt to distinguish Hairston, is misplaced. The court squarely held that there was no basis to consider whether the aggravators collectively performed the narrowing. Rather, the relevant question was whether the applicable aggravator individually performed the narrowing. Lainey, you can see where this is going, right?
Not looking particularly good for them. But ultimately, I was actually just having this thought that at the end of the day, her goal, like her job is just to try to go for all of these different, like, ways to get the death penalty off the table. And it's not, she's just going through the practice of it. She herself probably knew that all of this was going to get denied anyway, but she had to do it anyways. And, she's got a long trial ahead of her. And at the end of the day, it's her primary goal is going to be to get a not guilty verdict. But this is just like step one in like 100, and we haven't even started.
You kind of foresaw what's coming up. Idaho's selection phase requires that the jury weigh, and this is coming up. This comes way after the trial if Mr. Kohberger is found guilty. Idaho's selection phase requires that the jury weigh all of the mitigating circumstances against each applicable aggravating circumstance and determine whether the imposition of the death penalty would be unjust. The jury must unanimously agree that the death penalty is warranted. If the DP is imposed, then the sentence is reviewed by the Idaho Supreme Court to determine whether the sentence of death was imposed under the influence of passion, prejudice, or any other arbitrary factor, and 2, whether the evidence supports the jury or judge's finding if a statutory aggravating circumstance exists. Thus, importantly, eligible defendants are further narrowed through these phases, which defendant's argument does not consider. So this is filing all these motions at this time was really putting the cart before the horse. In that whole phase is yet to come.
Yeah, and I think that's I think from the little that we've seen, this judge's frustration, and I do think it's just Ann Taylor doing her job, where it's just like, we need to get the penalty off the table. We need to get death penalty off the table. It's just like, well, death penalty isn't even on the table yet because we haven't had the court. But at the end of the day, she's just putting it out there to start off with and build that basis from the beginning before court even starts.
Well, here's what she's putting out there. The state has identified 4 statutory aggravators in its notice that it intends to rely upon in requesting the imposition of the capital punishment. 1, at the time the M was committed, the defendant also committed another M. Well, there's 4 allegations in this case. 2, the M was especially heinous, atrocious, or cruel, manifesting exceptional depravity. And we went through the definitions of all these. These aren't just words that somebody pulled out of the thesaurus. These words all have legal breakdowns in terms of what has to be found in order to support those words. 3, by the M or circumstances surrounding its commission, the defendant exhibited utter disregard for human life. Again, a buzzword that's defined in the law. 4, the defendant by his conduct, whether such conduct was before, during, or after the commission of the M at hand, has exhibited a propensity to commit M, which will probably constitute a continuing threat to society. So through 4 separate motions, defendant seeks to strike each of the foregoing aggravators for various reasons. The court finds none of the defendant's arguments to be prevailing.
I feel like with the context of the asking for the extension, this also looks bad. Like, it looks worse, because I feel like this on its own, it's just like she put it out there, it got denied. But knowing that they weren't giving the enough cause as to why they need to research the discovery more, I feel like the combination of both of them looks a little bit worse.
And so what we are skipping past is a well-reasoned, sound legal argument that the judge made in shooting down each of the arguments that the defense made one by one. And, again, a lot of law. It's 55 pages. One of the arguments that Bryan Kohberger's attorneys had made, most notably Mr. Logston, was that the Idaho DP capital punishment law flies in the face of international law. And I think if you remember that day, the judge pretty much cut Mr. Logston down on that. And after a lot of law that we skip past here, what the judge says is that, however, these provisions provide no greater protection than what is already provided under the United States Constitution. While the United States ratified the international law, it agreed to abide by the foregoing prohibitions only to the extent that the 5th, 8th, and 14th Amendments of the United States Constitution ban cruel and unusual punishment. Thus, the international law as adopted by the United States does not impose any additional limits on the application of the capital punishment in the United States than what it already is constrained by the United States Constitution. So the United States Constitution is the number one law in the land. One of the things you learn in law school is that anything that any legislator does, and we hear them on TV every night saying they're going to do this, they're going to do that, they're going to do the other thing. The United States Constitution is over and above all of that. And anything that any lawmaking body, whether it's the legislature or your local town council, anything they do must be found to be in consistency with the United States Constitution. So this judge went through a very lengthy legal analysis that we kind of skipped over, but said, guys, the international law is not a greater law than the United States Constitution. And moreover, the United States Constitution tells the international people what we need to do here. So, Lainey, this goes to something you were talking about before, and I had mentioned that these motions are kind of putting the cart before the horse. The defendant's motion is not ripe. To be justiciable, an issue must be ripe. Ripeness is that part of justiciability that asks whether there is any need for court action at the present time. Notably, in all of these cases, the defendants were already on death row. Defendant has presented no case where a capital defendant who has not yet even been found guilty of M can challenge the method of execution. So what the judge is saying there is, guys, you brought this a bit too early, and yes, it can be brought back up again if and when Mr. Kohberger is found guilty at that time, and if he is sentenced to capital punishment. Another little side argument that had been made in the plethora of paperwork was lethal injection and firing squad have been found constitutional by the U.S. Supreme Court. Those are the two methods that they use in Idaho. Of course, they've tried and failed with lethal injection. And so now the Idaho legislature, in its wisdom, passed the firing squad. And the judge's take on that is that even if the defendant's motions were ripe, it has been foreclosed by prior United States Supreme Court precedent, finding both lethal injection and the firing squad to be constitutional methods of execution. And they cite an 1879 law, but then they also cite a 2008 law.
A little more relevant to 2008.
in that the wheels of justice grind slowly. 2008 was only yesterday.
Yeah.
In terms of the law, that's like nothing.
It's like pre-2000 or post-2000 are the relevancy.
Right. When I write a brief, I always look for cases. It's easy to find cases in the 50s and the 70s and the 90s. When I write a brief, I always try and find one that's 2000. So you're right about that. I always try and find something that has a 2 in front of it. So as a final slap in the face of the defense team, the judge says, defendant has failed to identify an alternate method of execution. I remember they went on quite a bit.
Ugh, that makes my skin curl.
So
it's like, well, how do you want us to do with that?
Read this motion several times and never mind. So the final order, I was looking for a nice conclusion, a nice paragraph that tied it all up. But after 55 pages, 54, not including the certificate of mailing, I think the judge just said, order. Based on the foregoing analysis, defendants' DP motions are hereby denied. So, you can bring a ton of motions, but the judge didn't make a ton of orders. He made one order. He said, that's it. So now
he said,
now we get into, remember in the very beginning, we said that there were a plethora or a blizzard of motions. Here's one of the most interesting ones, and it's a motion for a Franks hearing. Comes now Bryan Kohberger, Bryan through his attorneys, and moves the court to conduct a Franks hearing.
What the heck is that?
A Franks hearing is based on a United States Supreme Court case that goes back to 1978, Franks versus Delaware. And a Franks hearing measures warrants to see if there are any illegal or false or outright lies in the facts that are included in the warrants that are used to, or the affidavits that are used to get search warrants. And like everything else in this case, the parties stipulate to the sealing of the proffer and exhibits. And so the under seal proffer and exhibits are being provided to opposing counsel and court staff via email, but we can't have them. More secrecy. Nothing has changed in Boise, at least not yet. Nothing has changed in Boise. So people have been asking us in the comments and all over the world, really, when are they going to have a Franks hearing in the Kohberger case? Well, they're going to have a hearing, but the facts as of now are under seal. The next motion, there were about a dozen motions to suppress. Remember, we had said before, the next thing that's going to happen is a motion to suppress. Motions to suppress are brought in order to ask the court to keep certain evidence out. In other words, there may be evidence that was illegally obtained based on either Frank's motion orders, or otherwise that evidence is improper to go to the jury under the rules of evidence. So there were a bunch of them. We're not going to look at all of them because Ann Taylor is wanting to suppress Google, Apple, the cell information, and a lot of other information that was obtained by warrants. And, you know, we've looked at these in previous episodes, and pretty much she wants to keep everything out. If all of these motions are allowed, it's going to be a 5-second trial. But anyhow.
Yeah.
We're going to go over the really important ones, and you're going to see some new information about what happened behind the scenes in this case. Take a look at this. Due to the haphazard way in which law enforcement has kept and disclosed records in this matter, the following is the facts as best the defense can tell. On December 28th, 2022, Trooper Larry of the Pennsylvania State Police became aware of the objective of arresting Mr. Kohberger via Moscow, Idaho Police Corporal Payne. Remember Corporal Payne?
Long time.
On December 29th of 2022 at 4:45 p.m. Eastern Daily Time. And they put a conversion to Pacific Time, but we're going to forget that because this happened in Pennsylvania. So late afternoon, December 29th, a magistrate in Pennsylvania issued a search warrant with Mr. Kohberger's person. On December 29th at 2:22 p.m., so we're backing up a little bit, the magistrate in this matter signed an arrest warrant for Mr. Kohberger in Latah County. The affidavit for the warrant was signed by Moscow Police Department Detective Payne. At 2:43 p.m. Pacific time on December. Okay, we'll do Pacific time if we're going back to Idaho. At 2:43 p.m. Pacific time on December 29th, 2022, a criminal complaint and probable cause order were filed in this matter. 10 o'clock that night, Pennsylvania SWAT began preparations to arrest Mr. Kohberger. Despite days of constant FBI surveillance, Pennsylvania law enforcement did their own surveillance starting at 11:15 p.m. So, you know, we got the FBI doing its thing, and you've got the Pennsylvania State Police SWAT team doing their thing, two different government agencies not talking to each other. This is really important. That's why I redlined it. And despite the fact that days of constant FBI surveillance showed Mr. Kohberger was unarmed and tended to go for runs around his parents' neighborhood, police decided forcefully entering and arresting Mr. Kohberger within his parents' home was the best option. So on December 30th of 2022 at 1:14 a.m., the middle of the night, Pennsylvania SWAT and federal agents raided Mr. Kohberger's parents' home. Law enforcement arrested Mr. Kohberger, and then at 4:00 a.m., Pennsylvania State Police filed a criminal complaint against Mr. Kohberger. At 4:10 a.m., FBI agents searched Mr. Kohberger's person, took his fingerprints, took pictures of his body, and a DNA swab was taken.
What does that mean by took pictures of his bodies? I'm assuming that's clothed.
Well, not necessarily. I have seen photo, you know, when you're an attorney and you get into a case, you see stuff that, you know, generally, and I'm told that in the Richard Allen case, there were unclothed pictures of him in jail. One of the reasons cameras were kept out. So we don't know. It's all been sealed. But the thing I really, well, you know, think about it. People can hide guns. People can hide knives. People can hide what law enforcement calls contraband. So,
and it also like makes sense in this, like obviously if you're in that type of situation, you could have scars on your body from the encounter, so it makes sense
Right.
to be able to see the body. But it's also a very violating thought, but also this is a very intense crime in a very serious situation. So it's like, is it appropriate that you knew that this person was in their house and that there wasn't going to be an immediate threat and you send the whole SWAT team? Um, because obviously you think this person's a very dangerous person, but there's just so much about it that's so freaky to me.
I don't know. The thing that I took away from this was the section that says here that Mr. Kohberger was unarmed and he
Mhm.
tended to go for runs around his parents' neighborhood. Now, I used to do that when I would go home when I was in college and law school. I would go home to Pennsylvania, where I was born and raised. And I would go out for runs, because I knew the area. I was born and raised in that area. And you have your running clothes on. Maybe in the winter in Pennsylvania, sure, you have a jacket because you're running. Once you get going, you're heated up, so you're wearing a jacket. But so Kohberger goes home, as we know, famously in the car ride from in the Hyundai from Washington State back to Pennsylvania. He gets to Pennsylvania. He's there for the holidays. He's going out for a run. Now, remember that the Long Island serial killer was nabbed in the middle of Manhattan in the middle of the day without incident by police. Why could they not have done that to Kohberger? Why did they have to bang into his house with flashbangs? They broke the windows. They broke the front door. They went in like stormtroopers. Why did they have to do that?
Yeah. But it's like also, traumatizing to his family, which obviously this is a very serious situation. But you got to think about the other people in that household, the other people in the neighborhood.
Yeah, he has two sisters.
Yeah.
I believe both of them were home for the Christmas holiday. And he has parents who, as far as we know, they had nothing to do with this. And they have, middle-class jobs. They don't have enough money. And my understanding is they personally, out of their own funds, which are limited, had to pay for what the I won't use the word that's coming to mind, what the law enforcement officers did when they destroyed the house. So in any event, I sidetracked
because there's
myself.
no way theoretically, obviously we don't know what's going on there, but there's no way that they were going to know that this was going to happen. They're beyond the
No.
trauma, finding out this is your kids in this situation. Now you got to fix your house that you never, you don't know their savings accounts. It's sad.
My guess is that if they knew he went out for a run and if they just had a couple of cruisers stopped him, end of story. But anyhow, I digress. After all, if Idaho's law enforcement may take advantage of laxer restrictions in a different state, they may simply pause their investigation until their suspect is in that new jurisdiction. Or in the case of the FBI, state law enforcement could at any point, even within Idaho, call upon federal agents with the far laxer rules of the Fourth Amendment. What we're talking about here is what law is the court going to use in determining whether it was an illegal search and seizure? Idaho has its laws. Pennsylvania has its laws. And then the federal government has its own set of laws. That is a choice of law question. We studied that for a year in law school, and that's what this is all about. We're not going to bore you with it because I was kind of bored. But anyhow, the overriding law is the Constitution. The Fourth Amendment states unambiguously that no warrants shall issue but upon probable cause supported by oath of affirmation and particularly describing the place to be searched and the persons or things to be seized. The affidavit in support of the application for the issued search warrant included information that must be excised. They've got to take it out. What the defense team is saying here is that the affidavit was false. There were false facts in it. It was overbroad and it was not specific enough. And so we have to excise it or remove it, surgically, legally remove some of the information. Where information in a warrant was obtained via a violation of the Constitution, Idaho courts excise that information. And there are three cases, 86, 2006, and 2002. All information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy, and thus nothing in the warrant should remain. So their argument, I think, is a little bit of a stretch, but it's a constitutional argument that has to be taken seriously. They're saying since there was a lot of funny business in obtaining the initial genetic genealogy evidence, the whole thing should be thrown out. Mr. Kohberger has argued in a separate motion that the genetic genealogy investigation in this matter was done in violation of the Constitution. Additionally, he has argued there would be no investigation into him without that original constitutional violation. It is not that the results of the IGG sped up the investigation. Instead, they focused the investigation on Mr. Kohberger, a person whose only connection to the case was his mode of transportation and the shape of his eyebrows. Remember the bushy eyebrows thing?
That bushy eyebrows is crazy.
Two identifications of little to no value, as previously argued. As the Idaho Supreme Court has explained, while the initial burden in showing a factual nexus between the illegality and the evidence, the state must show it would have been discovered anyway. The state cannot make this showing without IGG. There is no case, no request for his phone records, surveillance of his parents' home, no DNA taken from the garbage out front, because the IGG analysis is the origin of this matter. Everything in this affidavit should be thrown out. So this is why late in 2023 into the spring and early summer of 2024, there was a lot of discussion about the IGG. And the basis of all of the motions, and we're only looking at a couple of them in this episode, the basis of all of these motions is that, you know, if you didn't have probable cause in the beginning under the fruit of the poison tree doctrine, everything that was obtained from that illegal, unconstitutional original work has to be excised or thrown out. So that's what all of, and most of us knew that when Ann Taylor was spending a lot of time on the IGG. We knew that this was coming, but here it is. Now we have a little bit more of a conclusion here than we had in the order. Mr. Kohberger requests this court suppress all of the evidence obtained by police via the warrant that permitted them to search his person. As explained above, this warrant lacked probable cause as written, given its heavy reliance on conclusions reached by law enforcement without the details necessary for the magistrate to draw its own conclusions. And because the warrant omitted exculpatory information and information that put into question the reliability of the facts upon which it relies, and finally, because the affidavit relied on evidence gained in violation of the Constitution, all in violation of the Fourth Amendment in Article 1, Section 17. So.
I don't really, with the way that things have been going, I don't really see anything good coming out of this. I mean, she hasn't been getting her way up until this point.
And now here's a motion to suppress the genetic information. This is the last motion we're going to take a look at because it's pretty repetitive, but this is another motion that was brought by them, and it is the granddaddy of the other motions, just basically Bryan Kohberger, through his attorneys of record, moving to suppress all evidence illegally gathered by law enforcement using his genetic information. This motion is made pursuant to the Fourth Amendment of the United States Constitution and Article 1, Section 17 of the Idaho Constitution. A memorandum and exhibits are filed contemporaneously in support. Guess what, Lainey? Under seal.
Of course.
You can't see it. You're not allowed. You pay taxes, but you can't see it. This motion, and I know attorneys in the audience will chastise me for that comment. Just be, I mean, there's been enough secrecy in this case. There's been enough secrecy in this case, all right? And at some point, we've got to open it up. This motion is being filed under seal pursuant to the Honorable Judge John Judge's previous order stating that pleadings related to this motion shall be filed under seal until the court could review the issues and arguments filed. The under seal memorandum and exhibits are being provided to opposing counsel and the court staff via email on the date of this motion. Hand delivery to the court for in-person filing will occur no later than November 18th, 2024. So they must have a good courier service if Ann Taylor and Jay Logston are located up north, and the court is down in Boise. I remember a long time ago when I worked in Boston before the internet took over, and attorneys were very skeptical. Attorneys were very skeptical of this internet thing, and I remember them not even wanting anything to do with email. Oh, we can't trust that. There were couriers. You couldn't cross the street in the financial section of Boston without one of these bicycle couriers going right in front of you. And they were deadly. They really were deadly because they went a million miles an hour.
They're going faster than the cars in the city.
And they went faster than the cars. They went faster than pedestrians. And you had to look both ways 3 times because these bikes just tore across the place. But so they filed the stuff in hand. They gave it to the other side by email, and we're still in the dark. And it's why. And I've been chastised by both sides, by saying, we don't know. And there are people that, we know he's innocent. We know he's innocent. And if you don't agree with us, you're an idiot. And there's other people, there's some YouTubers who are quite well known that we know he's guilty. If you don't agree with us, you just don't have a brain. If you don't agree that he's guilty, you just don't know how to think. And in our comment section, which we're going to get to in a minute, I ask people, don't personalize. Just because you disagree with somebody doesn't mean they're an idiot. Maybe you're the idiot. No, people can disagree. And I know I've preached this before, but people can disagree amicably and professionally and maybe open each other's minds, because the person that disagrees with you might actually say something that makes you run back and research. But do you want to know what William Thompson thinks of all of this or not?
Uh-oh.
So what did he file? Motion to strike defendant's memorandum in support of motion to suppress RE genetic information and memorandum in support of a Frank's hearing. So here comes the state and taking a swipe at, the momentum is going against the defense right now. So William Thompson, who's still in the game, despite my thoughts previously, he takes a swipe at her. Comes now the state of Idaho by and through the LatahCounty Prosecuting Attorney and moves to strike defendant's memorandum in support of its motion to suppress regarding genetic information and memorandum in support of a Frank's hearing because they violate the local rules of the 4th Judicial District. Now, you're expecting something substantive, right? You're expecting him to say something about why the genetic genealogy motion is wrong from a prosecutorial point of view and why the Frank's hearing shouldn't be held. So substantively,
I
right?
think it's really bold of you to say that we would assume something substantive from him.
Why?
You're like, well, you would expect it, right? It's just like, I don't know. We haven't had much context before.
When I saw the caption of this motion, I said, oh, wow, now we're going to get into the meat of the Frank's motion and why state prosecutors, and I know there are state prosecutors watching, not just from Idaho, but here in where we do this in New England, are watching them. Oh boy, we're going to find out something substantive that they have to say about this whole IGG argument that's now been raging out of control for a year and a half or more. So why does he oppose it? Because they violate the local rules of the 4th Judicial District. Memoranda in support of non-dispositive motions must not exceed 15 pages. LR 8.1. Defendant violated this rule when he filed a 37-page memorandum to support his motion to suppress genetic information, and a 33-page memorandum in support of his motion for a Frank's hearing without seeking leave of this court. See LR 8.3. Get out your paddle. Explaining page limitations in excess of those set forth in Rule 8.1 requires prior leave of court. A memorandum in support is not being filed with this motion as the state believes page limitations qualify as a routine matter. See LR 8.1. The state requests that the court decide this issue without a hearing. So there.
What do you think of that? Because it seems like they're being nitpicky, but then it also seems like the defense was negligent of doing their due diligence.
Here's how I feel. Do you really want me to answer that question?
I do. Are they just being nitpicks?
Well, here in Massachusetts, we have a 25-page limit on most motions, and rarely, because as you know, I like to be concise and pithy and get to the point, and spare me all the and later and there, but there's more. And if you act now, I don't like any of that, which translates into a lot of legal writing. You see a lot of that, and what we're going to tell you, and why this is important, and if you don't want to read all of you see that in legal writing. So yes, page limits are there, and yes, absolutely, to do this correctly, the defense team would have and should have known better. Sure, I know my local rules. I don't know anything about Idaho. I've said that before. I know my local rules, and I know. I think it's very rare. On a rare occasion, I asked for leave of court. For those of you who don't understand the perfunctory legal stuff, leave of court just means you're asking for permission. You're just, please, can I do this? So yeah, rarely. I think I can only really remember one time when I filed a request for leave of court to file a motion that's more than 25 pages. You got to have good cause. You've got to have, this is a complicated situation. There are 5 major issues. They're all not clear in the precedent at the U.S. Supreme Court or the Massachusetts Supreme Judicial Court. So I need more time. I need more pages. And it's always been allowed in my cases. And generally it is a perfunctory thing. So yeah, should they have done it? Yeah. Can she withdraw the motion and refile it? Probably. So she has that option. They should have known better. Yeah. But can they either posthumously ask for leave of court? Now, the way that things are going in that court, I'm guessing no, although that is an option. The other thing is they've met their filing deadlines, so they can file, they can unfile them, they can withdraw them is the proper term. They can withdraw them, refile them nunc pro tunc as though they had been filed properly in the first place, with the proviso that before refiling they can ask for leave of court. And the other option is before they refile them, just pare them down to the page limits. I find that a lot of legal writing is prolix. That was a term that was used by a Massachusetts judge one time. When somebody filed a complaint that was like 193 pages, I seem to remember. I don't know, that may not be the right number of pages, but some attorney filed a motion or filed a complaint actually in Massachusetts that I think was 193 pages. I might be off by a few. And the judge threw it out and said, this is prolix, which means excessively wordy. The rules of pleading require that we all be, brief and concise. So anyhow, that's what's going on in the case. There are a lot more motions. There are going to be hearings on these motions, but I don't think things are going well at this time for the Kohberger defense in this court.
It definitely looks like a lot of things are going against them right now, and it, the page thing. It's like as not being a legal expert, I understand that these things exist for a reason, and like you said, is just like getting rid of the 190 page. Like nobody wants to read more pages than they have to. Nobody's excited to do their homework, but. It's hard. A lot of things are reflecting very poorly on the defense right now, it seems. And I think mostly just all of them kind of stacked on top of each other, but it's not looking good for them in this new court.
I just wonder if the defense team, Jay Logston and Elizabeth Soth, and of course, Ann Taylor, I wonder if they're going, should we really have hired those 5 experts to get this case out of Moscow? I just don't know.
Yeah, I don't know. I mean, I'm curious what would have happened with Judge if they didn't actually leave, though.
Well, he's retiring.
Yeah, so would he have not taken the case? Would he have left in the middle of the case? Would he have stayed until the end of his case? He was probably so happy to get that case off of his hands to retire, but...
Well, get out the dun-dun-dun. I wondered whether one of the reasons he got rid of the case was because he wanted to retire.
Dun, dun, dun.
I mean, I don't know. I mean, it obviously is a complex case. I mean, with 13 motions being filed one day and 14 motions to strike the next. And, a lot more is going to happen between now and next summer. He had set the trial in June. The new judge set it back to August. And you know that there are going to be a lot more motions like this that are going to be filed. And if the trial goes in August, that's fine. If Mr. Kohberger is acquitted, I hate when people say end of story, but that would be the end of the story. If he's found guilty, then we go into the capital punishment phase, and then there'll be appeals forever and ever and ever. Amen. So I don't know.
That's putting it away as appeals for the next 20 years, which is what our current judge was also saying. It's just like, what's the big deal of doing it now when you're going to just be dealing with this case for the rest of your career?
Well, yeah, those DP motions are all going to come back up again in the end, when, as we pointed out together before, when it's ripe.
I wish that on no one to need to be dealing with the same case for year after year. Obviously, it's not good how they got there in the first place, but to need to spend the rest of your working career thinking about things like this is brutal.
So yeah, my closing thought is that I bet that Judge is going right now.
Definitely.
Like, I can go get the Christmas ornaments and set up.
Gonna do my Christmas shopping.
I don't have this hanging over my head. Whereas, these attorneys all have a lot of work to do, and Ann Taylor and her crew have demonstrated an ability to come up with a lot of, we don't say paper anymore because it's all electronic, fortunately, but she has demonstrated an ability to generate an awful lot of material. And, this court is, she filed, was it 12 or 13? I thought it was 13 motions. Then they said 12. In any event, a ton of different motions on capital punishment, and the judge just wrote one, order. Of course, it's 55 pages, but okay, those are my closing thoughts. Did you have any?
I just want to say thank you so much to everybody who watches our videos. It made me laugh so much to see our red apples and our green apples in chat and in the comments down below. And if you made it to the end of this video, we'll do another dolphin because the dolphins are really popular. But I thought it was so cute. I think it's so awesome the way that you guys engage with the video. The Redondo, I might be Redondo Beach was like, I saw they commented. It's just like, I was shocked to hear my name in the video. And it's just
Redondo.
also, yeah.
Now, wait a minute. Remind me again. What was because I was like paying attention to all my legal notes and stuff like that. What was with the green apples and the red apples?
It's just some apples to let you know if you made it to the end of the video, and then some green apples if you're having a Brattum, Brat Summer, Brat Winter, the usual, if they're bumping that,
Okay, thank you, everybody. Be nice, be kind. Remember, be nice in the comments. People are actually getting better in the comments. I only had to delete, I think, 2 of them this past week. If you disagree with us, that's fine. And if you go through our comments, you'll see people that say, we disagree with you, and here's why. But if you, personalize it, and somebody called one of our other commenters a bad word I can't say, and don't do that. Our commenters are our commenters.
We love you all.
It just, let's not personalize it and call people's names. Okay, have a great weekend. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.